you?
Great.
Good, good, good. 7 degrees when you woke up this morning, Andrea. Oh my goodness. Okay, here we go. Welcome to our first Forrest Solutions webinar. I am Deanna Bernard, Vice President of Staffing Sales. I would also like to introduce Anthony Davies, Chief Revenue Officer at Forrest and a specialist in outsourcing. Go ahead and say hi, Anthony.
Hello, nice to virtually meet you all.
Yeah, that accent you hear is East New York. No, actually, Anthony's from the UK. So let's get started here. So for the past 46 years, our company has addressed staffing, recruiting, and on-site outsourcing needs throughout the country. In this time of COVID, we helped solve the problems related to safety, security, wellness, and especially upon your reentry to your office. Our panelists today are Adam Guttell and Alex Villanella, principals at Jackson Lewis. Both advise in a broad range of employment law matters, including those involving discrimination, harassment, wage and hour, wrongful termination, and retaliation claims. Welcome, Adam and Alex.
Thank you, Deanna, for having us today. Want to thank Forrest Solutions specifically for partnering with Jackson Lewis to do this. We really appreciate it. Welcome to everyone in the meeting. We hope that today's presentation will be helpful to everyone as it's quite topical given the global pandemic that's going on. It's nice for me personally to be looking at a computer screen that is not a YouTube video of JoJo Apples or Snow White and the Seven Dwarfs. I have a 2-year-old at home who keeps us quite busy on the computer screen with YouTube. So it's nice to be doing something professional on the video screen. But we're going to be focusing primarily today on the Families First Coronavirus Response Act, FFCRA, as you will hear it referred to. While our focus will be primarily there, we want everyone to keep in mind the various other responsibilities that you have that may be applicable in this pandemic type situation. Specifically, we're thinking about, the various leave and accommodation related laws under your state laws or under the Americans with Disabilities Act. We'll get into all of that. We're here to help. We're here to hopefully give some helpful information. And, let us know if you have any questions or there's any specific topics beyond the ones we're covering that you'd like to be covered either now or in some future events.
Perfect. Thank you, Alex. Okay, so let's just jump right in for the first question. What is the Families First Coronavirus Response Act? And that's quite a mouthful. So as Alex mentioned, FFCRA. And you guys are going to hear some Brooklyn accent here, so bear with me. Who does it apply to, and what does it provide? Okay, Alex.
Adam,
go ahead, Alex.
Adam, go ahead. Why don't you take this one?
No, thanks, Deanna. Thanks, Anthony. Thanks, Alex. Of course, and as Alex mentioned, this is a very timely topic because we're looking at the end of the FFCRA. It's done as of December 31st. There is going to be no more FFCRA unless Congress reauthorizes it, comes up with a new stimulus package or something like that. Our view is, if they're going to do anything, this would be a pretty easy thing to extend because what it does is it provides benefits to employees. It extended FMLA benefits to employees affected by the pandemic, and it also provided some additional other benefits. And you've probably been dealing with it for the last couple of months. So this was something that was passed by Congress, signed into law by the president late in the spring. And employers have been dealing with it ever since. We have not seen, as Alex mentioned, we do a lot of advice and counsel. We litigate a lot of these cases. We've seen FMLA violation cases. We've not seen an FFCRA violation case at this point, but it is something that could come up. What does it do? First of all, it applies only to employers with 500 or less employees. Okay, so very, very large companies. It does not apply to. The thinking behind that, you'd have to go into the legislative history to figure out what they were thinking as to why they limited it in that regard. The concept being probably companies that large, either you're bound by a collective bargaining agreement with the union or you have other benefits that you're providing to your employees. But essentially what it does is, without going into all the weeds on it, it provides up to 2 weeks of paid leave. 80 hours is what the law calls for employees who are affected by COVID in some respect. There's about 8 different categories, including a catch-all, but the one that we've been seeing for the most part, has to do with employees calling in saying, I think I was exposed, I might be exposed, I'm going to get treatment, or I'm taking care of a family member who is being treated for COVID, and so I can't come to work. It gives that employee, 2 weeks, up to 80 hours. It's capped at $511 a day of paid leave, in this context. And the thinking at the time was, well, by the end of 2020, we'll certainly be done with COVID, so the law will expire at that point in time. That's not where we are today, which is why there's a battle in Congress to come to some sort of new deal to have more benefits. And in all likelihood, the FFCRA may be extended. They may call it something else. There's also a component to provide paid leave and unpaid leave to parents of children who have a school that have shut down on them and they otherwise can't come to work. That's if you cannot work from home. That's another concept that we'll probably address later. But that's in a broad stroke, that's the FFCRA. And by the way, one very important aspect of it is that the employer can take a tax credit. So if you are paying someone $511 a day over the course of 10 days, the 2-week period, you should be able to receive an immediate tax credit based off of your payroll taxes. So to get you to an almost neutral position. That's an accounting question. You want to speak to your accounting and payroll people about how to process that. And there is guidance out there about what you're going to need. Do you need a copy of the COVID test from the employee? Do you need a doctor's note? Do you need an email at least from the employee saying, I need to stay home for this reason? You're going to need that backup information if you're going to try to take advantage of the payroll tax credit.
And one other note, Adam's discussed the employer eligibility. One thing to also be aware of is that employee eligibility starts on day one of employment, which is a little bit unique, right? There's a lot of leave statutes and pay statutes that require some minimum duration of employment. For example, what comes to mind is the FMLA, right? You need to be employed for basically a year. In this case, day one, an employee, you can hire an employee, they can show up on their first day and they can say, hey, I've got this COVID related issue and I'm eligible for leave under this law. So something to be aware of for new hires.
Okay, so I have a question for you. So is it capped at 2 weeks, or what happens because sometimes people become reinfected with COVID, or maybe they had it and someone in their household or in their circle gets it again and then they get re-exposed. So is it capped at 2 weeks, or is it every single instance it's a 2-week period?
No, it's really just a 2-week period. It's the 80 hours. The school issue is different. You can continue to receive benefits and unpaid leave, and there's a maximum payout of the pay leave of, I think, of up to about $10,000 over the course of any sort of leave needed to stay home because your child is unable to go to school. And that means that the school is legitimately shut down. Not if your child is ill or something like that. It's that the school district that you're in, your school is shut down. But in terms of the, I think I was exposed or I'm seeking treatment for COVID, that's a 2-week paid period. However, you can't force that if someone's still ill and they're unable to work, you can't necessarily force them to come back to work. Alex, you see that all the time, right?
Yeah.
Even outside of the COVID context.
Yeah, so this is what I was discussing in my introduction where I said, I don't want people to get tunnel vision on just the FFCRA. It's a great question. So what happens when someone exhausts their leave under the FFCRA and they say, look, I'm still sick, I'm not able to return to work? What employers need to be thinking about at that point is their obligations under the Americans with Disabilities Act and under state laws that provide similar protections for individuals with disabilities. In New York, we have the New York State Human Rights Law, and in the city, the New York City Human Rights Law. And there are many states that have similar state laws that mirror or otherwise track the Americans with Disabilities Act. And basically under the Americans with Disabilities Act is what you need to be thinking about is, can the employee perform the essential functions of the job with or without an accommodation? If an employee comes to you and says, look, I'm still ill, I can't return, well, and I can't actually do the work because I'm too sick to work. Well, obviously they can't perform the essential functions of the job, which is the work. So does that mean the inquiry ends? And the answer is no. You have to engage the employee in an interactive process. That's fancy lawyer speak for have a conversation and figure out what does the employee need so that he or she is able to work or at some point will be able to work. And through that interactive process, you need to determine whether a reasonable accommodation is appropriate. And this is one that employers often get wrong. Unpaid leave, extended unpaid leave beyond the legal entitlement under the FMLA or the FFCRA can be an accommodation, and oftentimes in certain circumstances is required. So when the 80 hours are expired, it may be that as an accommodation to the employee, you need to extend their leave for 3 weeks or 4 weeks on an unpaid basis so that they're able to recover and able to safely return to work. So the inquiry does not end when the specific leave entitlement or payment requirements end. That's sort of just the beginning where I sit.
Now, Alex, let me ask you, what we see sometimes is, let's say the scenario you described where, okay, I got an employee who took the 80 hours for the FFCRA and they come back and they say, I still have some other health condition. Here's a note from my doctor. And it lays it out. I just need another month. If I can just take a month off of work, I should be good and come back. But that month comes and goes and the employee still can't come back to work. How much longer do I have to deal with this?
Right. So the answer is it's fact specific and there's no bright line test. There's nothing that says 6 months is unreasonable or reasonable or a year is too much. You have to continue to engage in that interactive process. And what we often work with employers on is working through that process. And that often includes making sure that you're getting regular updates from the employee and the employee's doctor, and even pushing back sometimes on the doctor. Because many of us, I know I do, have either a friend that's a doctor or a family member that's a doctor. And sometimes, they'll send a note that says, hey, Alex can't come to work. Don't tell Jackson Lewis. He can't come to work because he's got the sniffles. Well, as an employer, to me, the sniffles may not mean that the person needs to be quarantined or that the person can't perform the essential functions of the job. So you as the employer have the ability to reach out to the doctor through the employee and push back. And what that looks like is a letter to the doctor and to the employee. The letter to the employee says, we're going to be reaching out to your doctor. Please let him or her know. And please give him or her authorization to speak to us or write back to us. And then the letter to the doctor says, hey, Alex's doctor, you said Alex has the sniffles and can't come to work. Why? Why are the sniffles specifically prevent him from coming to work? Or is it that maybe Alex needs some sort of accommodation to come back to work? Can you please explain to us what what condition Alex specifically has, what his restrictions are? And oh, by the way, doctor, here is a copy of Alex's job description. Here is specifically what his job requires. Can you explain to me why he can or cannot perform these, or if he can with or without an accommodation? And oftentimes what you'll see is if it's legitimate, right, you'll get a very comprehensive response from the doctor that explains in detail what needs to be done. Great. At that point, you consider it and you make whatever accommodations appropriate. But a lot of times you also will see that pushing back on the doctor, suddenly the doctor starts to retreat because now that person's license potentially is on the line and they're not going to make misrepresentations that can get them into trouble. So if it was something that was a little mushy or, was a little bit of a stretch, at that point, they'll start to back down. And now the employee's in a position where they don't have support for their purported need for an accommodation or leave. And maybe they have no choice but to come back to work. So it's very fact specific. You've got to work through each scenario specifically. And you just need to make sure if you take nothing else away from that incredibly long-winded response, you should take these two things away. Be able to spot the issue. So when someone raises the need for leave or disability, think to yourself, I have some obligations here, and elevate it to the right person. And two, engage the employee in the interactive process. Don't just say okay and take the employee's word for it. Also, don't just brush the employee aside and ignore the request. You need to be speaking with the employee to try to come up with a solution.
Okay, let me add one more thing.
Alex, go ahead.
I just want to add one more thing there. And we see this all the time, which is if you're working with a lawyer, whether it's us or another counsel, start talking to them early on in the process. Right. Because we get these questions sometimes 6, 7, 8, a year down the months down the road, up to a year down the road. And we get a phone call saying, hey, we've got this employee and we've just let them stay out. And now, the supervisor's saying, this is a problem. It's a drag on the department. We want to terminate the person. Well, what did you do leading up to that to sort of work through, as Alex identifies, the interactive process? Can you start now and start to do it? It becomes it's tricky. It becomes a problem. So early on, when you're going to have this issue, start getting guidance about it.
Perfect. So I do have a follow-up question that came from the group. They want to understand, how does that response in reaching out to the doctor, the medical personnel, fit in with HIPAA and what an employer can know about an employee's medical issues?
It's a very good question. So HIPAA, and we are by no means HIPAA experts, but HIPAA applies to medical providers of healthcare services. It doesn't apply to employers necessarily, unless employers are in that business. The reason I said that you have to give a letter to both the employee and to the doctor is because the doctor is prohibited from sharing that information with you by HIPAA. So what that letter is intended to do is to obtain an authorization from the employee to authorize the doctor to share the information with us as the employer. In terms of what medical information we should or shouldn't collect, you need enough information so that you can make an informed decision as to whether the person's able to perform the essential functions of the job and whether there's an appropriate accommodation. In terms of storage of that medical information, you should segregate it from the employee's personnel file, right? Because what we don't want is an employee to be able to say somewhere down the road that, hey, they made this decision based upon my health condition, not based upon legitimate business reasons. So it's imperative that the employee have a personnel file with all their employment and personnel related information, and that there's a separate file with the medical information contained in there, to the extent you're keeping it at all. And Adam, okay. I think Adam can speak a little bit to what should or shouldn't be retained.
Yeah, I mean, one thing you can look at, I guess 2 points on that. One is when we Alex and I are litigators by training, so we defend a lot of these cases. It's very good for us if we have a situation where an employer says, we keep all our medical information for these requests and ADA issues. It's maintained by one person in the HR department. They're the only person who has access to it. So when there's a claim that comes in that an employee says, oh, I was terminated because my supervisor discriminated against me because of my disability, that supervisor can legitimately say, I have no idea about a disability. I don't know anything about that person's health information. I don't have access to it. It's only, John Doe in HR is the only person in the company allowed to have that information. So that's what needs to be maintained there. The other issue, which Alex touched on, is, all you need to know from the doctor is what the person can and can't do. Sometimes you will get a ream of information about, the person's medical history. That's not information the doctor needs to give you. You only need to know, if they're taking time off, how long do they need? And if there's some limitation on their ability to work, what is it? If you're working in a stock room and your job is lifting 50 pounds, the doctor needs to say, given their current condition, they can't lift more than 10 pounds, whatever it is. That's the limitation of the information. The doctors sometimes will give you more information that you're not asking for. And if they do, you can't unknow or unsee that information, which is why it's all the more important to segregate it, like Alex says, and keep it in HR, keep it in a separate file. Don't mix it in with the personnel file.
Right.
Okay, perfect. That's fantastic. Great information. I'm gonna move on to another question here. It's the holiday time of year, and you have employees who, some of them may be traveling home or traveling around the country or the world. And let's say an employee goes to a restricted state for vacation. Do I, as an employer, have to pay that employee to stay home? Because when they come back, maybe if it's quarantine for a certain period.
Go ahead, Adam.
So that's an interesting question, and I know we've got folks all over the country on this one. So that was something we were grappling with in New York for a while, because I think New York was one of the first states, and I don't know about every state in the country. We're a little jaded because we have Jackson Lewis. We have 60 plus offices around the country. So if we get a phone call from a client about something that's going on in Kansas or Texas or California, we're able to pick up the phone and call one of our colleagues in one of those other offices. So we don't necessarily know about other states, but I can tell you New York was an early adopter of this restricted state concept, meaning that they published a list. The governor had an executive order where they published a list and they said, if you travel to one of these states because the infection rate is above a certain percentage, and it would change on a daily basis, and it still is, you come back to New York, you must quarantine for 14 days. As an employer, this caused a lot of consternation early on. We got phone calls from employers saying, do I have to pay these people? And that's exactly the question you're asking, Deanna. And the answer to that in New York is no. If someone is making the choice, and it's a choice, to travel somewhere, not for business, but for personal reasons, vacation, see family, whatever it is, to a state that New York, for example, says, if you come back, you have to quarantine, the law in New York is actually very clear that you as an employer do not have to pay that individual for the time that they must quarantine for. And by the way, if it's done right and they come back to the state, either through the airport or I don't know how they were contacting people if they're driving, you will actually get a phone call or an email in New York State with an order of quarantine from the state. And that's something, there are fines if you violate it and all sorts of stuff. So as an employer, you can't enforce that order of quarantine. You don't have police power, but you can enforce your workplace and you can tell that person, no, you cannot come back here. I think you should follow your order of quarantine, but what you do not in the workplace is not our business, but do not come back to the office for 14 days.
And Adam, just to clarify, that's whether they can work from home or not, right?
Yes. So if you have someone who can work from home, and that's a separate issue. If it's a job, if it's an office-based job, and you can take your laptop anywhere and work from home, and a lot of us have become real good at this. A lot of workers who are office-based employees working nimbly in any location. If you're still able to do your work from home, you get paid for that work, right? You're still working as if you were in the office. If you have a manual labor job or something that requires you to be in a specific location, retail, what have you, then you can't work if you can't be in the workplace. And I think Alex probably has some thoughts about the potential wage and hour implications of that too.
Yeah, I don't want to get too far afield, but the point being, if it's a large topic, but under the Fair Labor Standards Act, the FLSA, which is the law that governs wage and hour federally, and then states have their own versions of it oftentimes. There's employees who are eligible to receive overtime, and there are employees who are ineligible to receive overtime. The employees who are ineligible to receive overtime are ineligible because they're exempt, and the basis for the exemption is because they're paid often is because they're paid a salary and they meet one of the exempt duties. If you have exempt employees who are at home and performing work, they need to be paid, right? You can't deduct from an employee's salary on an ad hoc basis because you risk threatening, jeopardizing the exemption, which would be very bad because then you become responsible for any overtime that they've worked. With respect to non-exempt employees, the real challenge with work from home is tracking those employees' time, right? When they're in the office, they're able to come in and punch a clock, but what happens when they're at home? I know when I'm at home, for me as a lawyer, we're exempt, obviously. I'll do a couple of hours of work, and then the CEO of my house, my 2-year-old son, kicks in the door and says, "Papa, eat food." And I run down to make him a PB&J sandwich that he proceeds to eat a quarter of, and I eat 3/4 of it. And that's why my face looks so puffy on camera right now. But the point is, I'm able to work, stop work, go back and forth, and it doesn't matter because I'm salaried exempt. But if I'm a non-exempt employee, right, I need to be paid for the time I'm actually working. And how do you track that? My clients have different ways. Some have software, some have timesheets. But ultimately, the burden falls on the employer to ensure time is accurately recorded. And what I anticipate we're going to see a lot of litigation about in addition to COVID-related litigation, is non-exempt employees who are working at home who are saying, I only got paid 35 hours this week, but I worked 52 hours. I was checking my email. I was doing this. And ultimately, again, the burden's on the employer to track that time. So employers need to be thinking through, if they're going to allow employees to work from home, which employees, if we're going to allow non-exempt employees to work from home, how are we going to do it in a way that provides us the most protection against some sort of claim that the employee is making that they work more hours than we believe they work? And there's various ways to accomplish that. Way too much to talk about at this point, but you need to at least be able to spot the issue.
Alex, it's a great idea for a follow-up webinar, Alex. We have many ways of doing that.
Multiple webinars.
We have thousands of people across the country working from home for our clients, and many ways of doing that. It's a good idea. I've made a note.
Right.
And let me just add, in the narrow context of what we're dealing with today, one of the things you want to consider is maybe an all or nothing approach. You know, we deal with a lot of medical practices, for example. So most people in a clinical setting, that's an in-office job. There's no problem, right? But if you have someone who's like back office doing billing or some paperwork, and we get these questions all the time, you know, oh, that person can't come in for a variety of reasons, health issues, or they travel to another state or whatever, and they feel bad, they want to do some work from home. No good deed goes unpunished. It could be a problem, like Alex identified. So either you say, no, you're staying home and you're not working, and this is going to be either paid or unpaid time off, and then you come into the office and you do your job. Or if they're going to work from home, you have to, as Alex said, have some form of tracking the actual time that they're working.
By the way, on a non-legal topic, these webinars are very difficult because I have no idea if my jokes are falling flat. So spam the chat if you like my jokes, or tell me to shut up and stick to the law. I'm happy to do that too, but I need some. All right, good, Tanya. Thank you. Good. All right, keep going.
Perfect. Okay, that was great. Okay, so the next one, which affects a lot of people, but not me, my sons are 22 plus. An employee wants, so Alex, this will be you. Hopefully we won't be doing this when the time your kids go to school. An employee wants to work from home. Anthony can address this because his or her child has remote learning. Do I have to agree for my employee to work from home, and do I have to offer that benefit to all the employees of my company?
Go ahead, Adam.
Say that. Go ahead.
Yeah, that cuts across a couple of different areas. There's the FFCRA benefit, right, where someone can't come into work because their child's school is closed and they have to take care of childcare obligations. That's an all or nothing situation. You're either taking advantage of the FFCRA and you're not working, you have to stay home and you get some benefit in terms of pay under that law, or you're working. It's one or the other. And so if you have a situation where people are coming to you saying, oh, you know what, I have to stay home because my child's school is closed, it's remote, but I want to work from home, everything Alex just talked about comes into play. How is that person going to work from home? Are they an exempt employee or non-exempt employee? If they're non-exempt, how are you tracking their time? How are you evaluating whether or not they're doing good work for exempt and non-exempt? So yes, you can offer that because of that, but you're going to have to offer that to all employees, because the issue there is, why is this employee any different than any other employee? Because they have a child who has a remote school situation. So if you have someone else come to you who says, I need to work from home for reason B, because this homeschool is reason A, you have to treat those employees equally. Otherwise, you open yourself up, you become exposed to claims of unequal treatment or discrimination. Oh, they let that employee work from home, but they're not letting me because pick a protected category. I have a disability, it's something under Title VII or under the state protected category laws. So that's one of the reasons that you want to be very careful about that. It's sort of an all or nothing approach. You don't necessarily take it on a case-by-case basis like you would with the interactive process and a reasonable accommodation for a disability. This is something where you want to balance the goals of the office of the company and what you can and cannot offer to employees without raising the possibility that another employee is going to say that's unfair.
Right. And to that point, Adam, my intention, by the way, even though it sounds like this is what we're doing, is not to scare the hell out of everyone in this group. But when we're talking about, this employee gets to work from home, what about me? one thing you need to be thinking about, Adam mentioned unfairness, is how are we drawing distinctions between employees, right? It should always, the distinction should always be based upon legitimate business reasons. For example, this particular job lends itself to someone sitting in front of a computer and being able to do it from home, whereas this particular job requires face-to-face interaction. The reason I say you want to make sure you tie it to a legitimate business reason is invariably what's going to happen is an employee who feels like they were treated, quote, unfairly because they were not allowed to work from home will find a basis that is protected by law for why they were treated that way. For instance, you've got 3 employees, you allow 2 of them to work from home, 1 you don't, all 3 do the same job. The 2 employees you allowed to work from home are under 40. The 3rd employee you asked to work and you prohibited from working from home is over 40. Guess what that older employee is going to allege now? He or she is going to say, the reason I was not allowed to work from home is because I am older, right? And you need to have, excuse me, a legitimate reason for why you're drawing the line where you drew the line. By the way, in that circumstance, I would not say because that employee doesn't know how to use technology as well as the other employees who are staying at home. Because guess what that is? That's a euphemism for age discrimination, folks. So be sure that when you're drawing these lines, you're drawing them in ways that make sense and that are tied to legitimate business reasons. I frankly prefer policies that are all or nothing. Doesn't necessarily need to be applied to the whole workforce. But when I say all, it should apply to maybe entire departments or entire job groupings to ensure that we're not having to make these ad hoc decisions, because those are the decisions that can get an employer into some hot water.
Another, we've sort of addressed a number of key topics, but one thing that and the idea is that you think about these issues as they come up and then you seek guidance for it so that you're not making the wrong decision. Another thing to keep in mind, and we saw this during the height of the pandemic, is shifting responsibilities. If you're allowing the people to work from home, but you're saying, okay, we know you're not going to be as productive working from home, so we know you're going to work less hours, so we're going to adjust your pay accordingly. Or even if they're working in the office and you're adjusting their pay because the revenue is not the same and you're not making enough money. Figure out first, you sort of should have a checklist of things to look at. Are you treating all employees in one category the same? Did this person, have an issue that they raised in the past? Another issue is anyone on a contract? You don't want to raise a breach of contract claim where someone says, okay, I signed this contract, I'm going to work here for 2 years and I'm going to get paid X. Now you're changing my pay. You're actually violating that contract, and there could be real exposure for that. So, it's a smaller group of employees. Most employees don't have contracts, but you should go through that process of checking on the box to see if that's an issue you need to address.
And one point on an unrelated topic, going back to where we started, there's a question from Anonymous, very scary. I thought to qualify for the FFCRA, you have to be employed a minimum of 30 days. Are you saying 30 days? Are you saying they are eligible day one? It's an excellent question. And I realize we may have not been clear at the beginning, so I want to clarify. 30 days is for the emergency FMLA expansion. That covers childcare. That covers when your child's school is closed. The eligibility on day one is for the emergency paid sick leave provision of the law, which is for your own health condition. I'm quarantined due to COVID, or I'm suffering from COVID. Day one, you're eligible for that. So that's the distinction between the two. Anonymous, you should have attached your name to the question because it was an excellent question. And I'm sorry we weren't clearer before.
Oh, thanks for that clarification. Okay, the next question. This is something that Forrest has been doing for a lot of our clients. As far as collecting people's health temperature when they walk in the door, able to do that, become like wellness ambassadors. So the question is, now that they have this information, can an employer keep that information in a database? And if they can, what can they keep?
The answer is an employer should not. What an employer should record is the fact that they took employees' temperatures and that the employees were okay, or that there was some sort of certification process. I mean, look, like everything else we're discussing, what would be the legitimate business reason for keeping the temperature itself, right? There isn't one. There is a legitimate business reason for recording the fact that we've made sure that everyone who's coming to work during this pandemic is healthy and is able to work, but there's no need to store the temperature, just the fact that it was performed and that the employee either was allowed to work or wasn't. Adam, anything you want to add there? Do you disagree?
No, that's right. And this is almost somewhat of an exception to even ask those questions, to even take someone's temperature. The Equal Employment Opportunity Commission, which is the government agency that sort of oversees fair employment on a national level, has issued guidance. And the EEOC says, yeah, it's okay, as Alex identified, for a legitimate business reason to make sure you don't have sick people coming into the office to spread the disease that's causing the pandemic. You can take people's temperature, you can have them fill out a questionnaire, you can ask questions about their health condition and whether or not they've been exposed to other people. But as Alex said, you can't hold that information, you can't store that information because it is protected health information. You shouldn't be doing that. And there's also just a bunch of unintended consequences that could happen from storing that information. If it gets lost, if it gets into the wrong hands. You just need to know whether or not that person is cleared to come into the office that day.
Okay, perfect. Okay, so I'm going to talk more about the workplace here and what you can require an employee to do or not require them to do. So let's say you have an employee who just absolutely refuses to wear a mask in the office. What do you do? What does an employer do?
This is a really hot button issue, and what I'm going to attach to your question is also the hypothetical where an employer wants to require a vaccine.
Okay.
The answer to both right now is probably similar, and the answer is you can require someone as a condition of their employment, as a condition of coming into work, to wear a mask, right? If an employee refuses, you can terminate that employee. However, just like when we're discussing leaves and everything else, we need to be cognizant of and aware of the Americans with Disabilities Act and related state disability laws, which require us employers to consider whether an employee has some sort of medical condition or disability that would require some sort of accommodation or exception to the rule. For example, when it comes to a mask, let's say an employee has some sort of skin condition or something that medically prevents them from being able to wear a mask. Well, then again, we need to talk to the employee and perhaps maybe even the employee's doctor to figure out what we can do to accommodate that issue. With respect to the vaccine, mandating a vaccine, similar issue, similar inquiry, but you have to add something else. Oftentimes there are people who refuse to take a vaccine for religious reasons, right? Under Title VII and state laws and various other anti-discrimination laws, like with a disability, employers have an obligation to accommodate bona fide religious beliefs. In order to do so, again, you need to speak to the employee, engage the employee in an interactive process to figure out what accommodation can be made for this specific requirement based upon the employee's bona fide religious belief. So the short answer to can you require a mask is yes. The long answer is yes, but you need to be thinking about potential accommodations for these various reasons.
Okay, now I have a follow-up question to that. Does an employer have to supply a mask for their employees when they come to work? So let's say an employee says, I don't make enough money, I can't afford it, money's tight. That's why I'm not wearing one, I can't afford it.
It's a great question. It's my opinion, taking my lawyer hat off for a second. I think it makes a lot of sense to do that. And I think employers are taking, whether there's a law that requires it or not, I think employers are taking a risk, a chance by not providing it, because one of the things that's going to come out of this beyond employment, beyond the labor and employment world, is likely negligence type lawsuits where an employee is going to claim or an individual is going to claim, frankly, they got COVID from entering into a business that didn't have PPE. Now, workers' compensation statutes across the country typically prohibit employees from suing their employers for workplace-related injuries because there's insurance for that. There's workers' compensation for that. It's unclear at this point, and we're not workers' comp attorneys, so I can't say it definitively, but if it's unclear at this point if contracting COVID in the workplace would be covered by workers' comp. My guess is it will be. But if an outside third party comes into your place of business and you've not provided proper PPE to your employees, there's no reason why that outside third party can't sue you and say, look, you were negligent in protecting me, the customer, from COVID because you didn't provide your employees with appropriate PPE. So that's sort of the more practical answer. Legally speaking, and Adam, please jump in if you disagree, it's really a state-specific issue. Each state has its own rules about what employers need to do in terms of PPE. In New York, there's an executive order that requires employers to provide cloth face coverings to its employees. I'm sure there are other states that have very similar requirements. I would bet dollars to donuts California has it because New York has essentially become California East when it comes to workplace protections and employee liability laws. But the answer is it's state specific, but practically speaking, I think it makes good business sense, both as an employer and as a provider of services or goods or whatever it is you provide, to provide PPE to your employees.
No, I agree with that. The other thing that you can keep in mind is that, as Alex described, if the rule is you have to wear a mask in the workplace and people are violating that rule, it's just like any other policy you have. So if you came to us and said, put together, best practices, what are your policies you're going to push out to employees? You would include all of the things that the states want you to do in the state that you're operating in. And if employees violate those policies, you engage in progressive discipline because it is your obligation to maintain a safe workplace. There's an OSHA issue involved in this. We actually have seen early on, we didn't see this case, but there was a very large retailer that got sued outside of Illinois, in Illinois, outside of Chicago, for an employee who died, they believe, of COVID. Of course, the big issue there is that they contracted in the workplace, did they not? I read the complaint early on because we did a seminar on this. It read like every guideline the CDC put out of what an employer is supposed to do with respect to having a safe workplace, right? And the allegation was this employer did not do the following: provide PPE, sanitize the workplace, maintain social distancing, all the things that you now see in the workplace. And so that's the allegation, that the employer was negligent and caused this individual's death as a result of that. Case is unresolved at the moment, but that's what you're going to see. And our point to an employer is, why get yourself in that situation? The mask issue of late has become somewhat of a hot button issue. You're going to have people in the workplace who want to feel differently about it. It's not a free speech issue. This is about a protection issue in the workplace, and you don't want to get sued by the other employees.
Right. And to Adam's point about OSHA, OSHA has a general, I don't know the specific name for the provision, but it's basically like a general standards provision that requires, generally speaking, employers maintain a safe workplace for their employees. So the mask issue could fall under that, although it doesn't specifically enumerate PPE in pandemic circumstances. There are more specific provisions in OSHA that require PPE for other things like handling chemicals and cleaners and things like that. So there's no reason to believe that OSHA would draw a line at virus protection or pandemic and say suddenly that PPE is not required. So while it's not specifically enumerated there, certainly it could get gobbled up in OSHA's catch-all provision.
If I could just add, we spoke before about how the vaccine, we're a bit early on in the vaccine to really understand how it's going to be, how it's going to affect everything. But it'd be good to hear in the chat whether or not you think that might be something good to cover off in one of the follow-up webinars that we have. That's certainly our plan.
Yeah, Anthony, it's a great point, and the EEOC is telling us that they will be issuing some sort of guidance on mandatory vaccines, on their position on mandatory vaccines, whether they think it's violative of the law or not. Additionally, there's, I'm sure many of you have heard about this second stimulus bill or Coronavirus Relief Act that's making its way through Congress or trying to make its way through Congress. One of the red line issues in the bill that's a sticking point for the Republicans is some sort of liability relief or liability exemption for employers, right? That employers cannot be sued for employees that contract coronavirus in the workplace. It's unclear exactly what's going to be in there, but that's being held up at the moment, but that's in there and Republicans are insisting on it. I have no idea at this point whether it'll pass or not, but that I think Anthony, you're right. It would make sense to have a webinar specifically on those issues because I think it's all one and the same. It all, the mandatory vaccine, EEOC's position, and whether or not employers are going to be subject to liability for coronavirus, people contracting coronavirus and things like that. It's all, I think it all goes to the same point.
Right.
Okay, great. Cal, go ahead.
I was going to say, just before we move on, I see in the chat, someone's asking a question about something we touched on at the beginning. So I can address that now before we get too far into something else.
That's fine.
Yeah, the question is, do you think we're going to find out whether or not the FFCRA is going to be extended before December 31st? And the answer to that is no one knows, right? Unless you're working in Congress. I mean, every day you read, the newspaper, either, it looks like they're close to a deal or the next day they're nowhere near a deal. So that's all it's going to depend on. But the bigger issue is, think about it this way. The FFCRA requires you to provide certain payments, certain rights to your employees. If the FFCRA goes away on the 31st, you still have all the obligations we discussed at the outset. An employee comes to you and says, I think I have COVID, or I'm getting tested, or whatever one of the FFCRA reasons to stay out of work is, you have to work with them through your state human rights law and the ADA. Okay, stay home. You can take some paid leave if you have paid leave banked up, and you can use that for that time. If you've exhausted your paid leave and you have a health issue, we're going to go through that interactive process, and it may be unpaid leave that you're staying home.
Adam, and one question. So what if an employee contracts COVID and needs leave pursuant to the FFCRA, and that leave starts December 27th, and the bill expires on December 31st? Do they get the full 80 hours? Do they only get, the 4 days between the 27th and the 31st? How does that work?
That's a good question. I mean, if we got that question from a client, my argument would be we should give them the full benefit through the end. If they're implementing the
lawyer to say, sorry.
If they're seeking the benefit prior to the expiration, you're going to get the full benefit. The outstanding issue in my mind is what's the IRS going to do with that when it comes down to if you're going to seek some sort of tax credit for the payment. And keep in mind, you're now into the next year too. So when is that payment? This is an accounting question. Are you, based on your weekly payroll, if someone seeks it on the 29th and they don't get paid till sometime in January, are you even going to be seeking that payroll tax credit, in 2020 or 2021? That's something you may want to take up with your accountants.
And what if the employee doesn't use the full 80 hours? What if they use 40? Can they use the other 40 at some point in the future? Or does it have to be contiguous?
No, they can use it in the future. But if the FFCRA expires on the 31st and then they want to use it in 2021, it's no longer there.
Right.
Okay, so that sounds good. I loved it, Alex, when you said California East. As long as we get the California weather here, that'd be perfect.
It's not a compliment.
Well, I meant the weather. I'm talking about the weather.
Well,
I know what you meant.
It beat the weather.
I know what you meant.
I wish.
So I do have a follow-up question. So you say people have to, as an employer, you're saying, I want you to wear a mask in the office. Do they have to send it out via an email, like a PPE policy via email? Do they have to have some kind of acknowledgement from the employees that they've read it, they've understood it? What's the responsibility from the employer as far as dispensing what they want, what the standard is in the office?
It's an excellent question. There is, in New York, you're required to provide the PPE, but there's no specific requirement that there be a policy. I imagine other states are the same way. And the answer is best practices. You should have a written policy. That way there's evidence that you've mandated this for various liability purposes. And the reason a policy is also good is that, again, you don't risk someone accusing you of not applying this policy uniformly, right? If it's a policy that goes out to everyone, it's in writing, it makes it harder for an employee to say, oh, they required me to do this, but they didn't require the other employee to do this. And again, it's always a good policy. You know, if you're going to have a policy, you can put it in your handbook, you can issue it as a separate policy. It never hurts to have a receipt, an acknowledgement of receipt, again, for evidentiary purposes. But there's nothing in the law, as I understand it presently, that would specifically require you to put it in writing, but it certainly is a best practice.
Okay, perfect. Okay, so the next two questions I'm going to combine. What do you have an employee? What if you have an employee who has COVID anxiety or a chronic illness and doesn't want to come to work? They don't have COVID, but either the whole COVID coming to the office or coming to the workplace stresses them out, or they have chronic illnesses that they don't want to expose themselves to the office, or maybe a close family member, a spouse, a child, a parent has those chronic illnesses.
Adam, you want to take this?
Yeah, well, the first part I think is everybody, which which is,
yeah, it's true.
By the way, is part of the answer, right? Like, we've all been impacted by this. Show me the person who hasn't been impacted one way, whether it's just waking up in the morning and feeling not as cheery as you used to feel, or at the end of the day being exhausted because you didn't work any longer hours, but there's just something about this environment that's completely draining, or panicking, about, what the future is going to bring, or being upset because you can't do the things in your life that brought you joy that you did, pre-March 2020. So in that respect, if someone says, yeah, I don't feel great, I have COVID anxiety, they're giving it a label, right? And they're telling you about it. We're back to that sort of first point that Alex was saying, which is, okay, they're identifying a health issue. They've used the word anxiety. But you have to have that interactive conversation with them. If it's nothing different than what I just described, which we are all experiencing, and they can't point to some sort of, treatment. Oh, well, I have COVID anxiety, and yeah, I just, I don't feel that great because I can't go to the gym anymore. That's not really a health condition for which you need to provide an accommodation. Now, it's case specific. I mean, I wouldn't jump to that conclusion. Talk to your lawyer, talk to us about it. But if the answer is, yeah, I'm suffering from some real anxiety and I've been seeing a therapist for the last, couple of weeks, say, okay, can you get us a note from your doctor telling us what you need? Is it time off of work? Is it, some accommodation? Is it you need to leave early in the day to go see your therapist? Whatever it is. And then you work through that process with the employee. Same issue with and by the way, this is I think that your question suggests that this is in a workplace that's fully functional. You're operational, everyone's in the workplace. It's the type of workplace that you require people to be there, and you don't have people working from home. So what you're looking at is someone looking for an accommodation from engaging in that workplace, right? From being let's say a 9-to-5 employee in that building. If someone says, I have a chronic illness and my doctor said, I believe, or my doctor said, it's dangerous for me to be in the general public because if I catch COVID, it's more dangerous to me than someone who doesn't have my chronic illness. Same issue. You want to talk to that employee, you want to engage in the interactive process, you want to get documentation from a healthcare provider identifying what they need. We've seen that. We've seen those notes that say, employee A suffers from disease Y. At the moment, it is ill-advised for them to be working in a setting with other individuals. They require an accommodation, and then you engage in that interactive process.
Yeah, we at Forrest, we've seen that as well, when people just couldn't come to work because of that, and we put in contingent employees so that employers can cover their roles while these folks are out for whatever reason. So no, I understand perfectly how that affects folks going on there. Okay, so the next one,
I don't have an answer for, but people should start thinking about, because this will be maybe for our next session or another session after that. So let's say you have that employee and they say, it's not safe for me to be in the workplace. And then you push out, a mandatory vaccine program. And then that employee says, but I don't want to take the vaccine. I think there's a sort of whole decision tree you're going to have to go through that will probably develop over time when we get these questions. But I think it's not going to get easier in the short term. I think it's going to get a little more complicated.
Well, the one advantage is, unless anyone's in the medical field, they have a little bit of time to work on these things and think about the different scenarios, and either contact Jackson Lewis or contact their own law firms to get advice, employment law firms to get advice on that going forward. So be prepared, I guess is what you're saying, just in case something happens. Okay, so I want to open up to any other questions that we might have out there.
I see a few questions. I just see this question and answer box. I actually think I ended up addressing all of them.
I think so too.
Anyone has any, please type it into the chat or the Q&A box. Either way is fine.
Okay, how about an employee? I think we may have addressed this, but I want to make sure. An employee is exhausted. That's my Brooklyn guys. All paid leave because of exhausted, because of an illness, and they still can't work. What do they do? Do they go back to what you said earlier, Alex?
Yes, so then the analysis is on one that you perform under the Americans with Disabilities Act or the state version of that. And it's interactive process. Is there an accommodation? And the accommodation can be additional unpaid leave. And employers hate me because they ask me, well, how long do I have to let this go on? And the answer is, as long as it's not creating an undue hardship on your business, you have to allow it as an accommodation. And what is an undue hardship? It depends. It's fact specific. It depends on your workforce. It depends on your workplace. So it's really something that needs to be examined on a case-by-case basis. But the simplest answer is there is the ability for an employee to take unpaid extended leave pursuant to the ADA or a state law. It's something you need to engage with the employee with and consider.
One thing that courts have done to help us, and it's in case law, is indefinite leave. Alex, if you get the question, if you get a doctor's note back that says, I don't know when this person can ever be fit to work again in this workplace, or words to that effect, you have to accommodate that?
No, the answer is no. You don't have an obligation. Thanks for clarifying that. You don't have an obligation to provide indefinite leave. So to Adam's point, if you get a doctor's note that says the person will be reevaluated in 6 months, you're 100% within your rights to send that doctor a note, again, through the employee's authorization, that says, no, we need to understand when specifically this person will be able to return with or without an accommodation. It can't be open-ended. You don't have an obligation to accommodate it on an open-ended basis.
Okay, I just have a question here. I'm going to read it. As a company, this is from Anonymous, I believe, did I read this already? We're not bound by FFCRA, but have created an emergency sick leave for employees impacted by COVID. Do you recommend we continue providing this paid leave to associates in 2021?
It's a business decision. It's not necessarily a legal one. One word of caution on those additional leave banks, depending on where they're being derived from. I don't know if it's some companies have implemented like a sick leave donation fund where they take sick leave from other associates or employees and put it into a slush fund, let's call it, and distribute it that way. There are certain wage and hour and tax issues that would need to be addressed specifically there that just way too much to discuss right now. But in terms of whether you should continue that, setting aside the potential tax issues, it's really a practical consideration. I think for morale purposes, it's great. It shows that you're a company that's being proactive and trying to help out its employees. But legally, there's no specific answer there.
I mean, let me just add to that. As I mentioned probably a couple of times, Alex and I litigate these cases. We defend them, so we see where the problems are. There's always the technical employment law answer, which is what can you do, what can't you do? And then there's how do you avoid lawsuits? Right. And there's no bigger way to avoid lawsuits than to have happy employees and to have them, feel that their employer is helping them rather than out to get them. And a program like this probably serves that purpose. So if the cost is not, phenomenal, it may be something worth continuing.
Much better answer than mine.
Well, this draws to the end our first webinar. We're going to be doing another webinar on January 12th. Hope you come as well. We'll be sending out the information. I hope this was informative for everyone. Jackson Lewis, thank you, Adam and Alex, for doing this. I took away a few key things. One is to engage with your employment attorney early. Don't wait until it becomes later on in the issue. Also, to keep the medical information separate from the employee personnel information, as well as just have open discussions with your employees and treat all the groups the same. From Forrest Solutions, we help people when you have people go out to be a contingent workforce to help with cleaning your workspace, making sure that you're following PPE guidance and all of that. We will thank you for joining us. We hope this has been beneficial. Thank you so much all. Have a good rest of the day and happy holidays.
Thank you, everyone. Thank you, everyone.
Thank you, everyone.
Thank you. Thank you, Deanna.
Bye, guys. Thank you.